Many ask in the communities, hey, I found a customer, or I'm talking about a business owner, now they put a cleaner to do the work, and then a few months after, they actually handshake with one another and abandon the company who actually created.
Just pick up the phone. You'd be surprised how far you can get. I can't draft you a good contract unless I understand your business and we have that personal relationship, hopefully, right? And then understanding not only your business, but how that business interacts with the client. What happens if someone doesn't pay, even if the contract says that they should? You don't want to drop a 500-page contract on someone's desk. They're not going to read it. They're going to get frustrated. You want to have an attorney who understands both the business, but also your goals as a business owner. In a lot of ways, having these contracts in place is a form of cheap insurance. In dealing with your clients, dealing with insurance companies, or anybody in any context.
Hey, Clinton.
Hey, John. How are you?
Good. Thanks for coming in.
Thank you so much for having me. I really appreciate it.
Likewise. So you are a lawyer.
I am. I'm currently an associate at Offit Kurman, based out of Columbia, Maryland, which is where my main office is. I work in the business transactional and corporate department. So my day-to-day duties are mostly operating as general counsel for a variety of companies, doing business transactional work, so day-to-day contracts. And I'm also involved in mergers and acquisitions for a variety of companies in a variety of industries. Prior to law, I was in banking and finance for a while when I was in Northeastern, down in Boston. And then I also started and sold a software as a service company for the healthcare industry. And so I have a bit of background in both the business world and the legal world. And in addition to that, I also have a master's in taxation. So I'm involved in some of the corporate structure and also tax planning for some of our clients.
So you're a practicing attorney, you practice business law.
Correct.
You have experience with taxation from the law legal standpoint.
Correct.
And you are a founder who started a software as a service company, raised some funds, and then you closed?
Correct, yeah. It was a college friend of mine. We both got in early on the company, did some investments on our own, both individually, and then we went through a couple rounds of funding based out of an incubator out of Boston.
That's impressive.
Yeah, it was fun. It was a great learning experience, and frankly, it gives me, I think, a better insight into the business operations of our clients as opposed to from what I would say, a theoretical legal view.
Yes, I totally agree, because you actually had dealt with those challenges yourself. Speaking of challenges, I'd like to bring up some questions, if that's okay. Most of the people that are watching are those who either have a cleaning services companies or would like to start cleaning services companies. And by monitoring the YouTube channel, I see quite a few people giving advice on what they think they should be, but I haven't seen credible attorneys coming in, reputable attorneys from the reputable firms such as Offit Kurman, answering to these questions. And these are mostly asked questions in the community, as you follow community as well. Before we get it started, just to make sure that this is not a legal advice, right?
Correct, yeah. So not to sound trite, which this is going to sound trite, these are all general considerations that people can make in the context of how to structure a business from the start, how to perhaps run it while it's normal day-to-day business transactions, what kind of contracts should you have, and perhaps some planning on the tail end in the event that you would want to sell. Any of these considerations at any point in time, if people are serious about this, they can either reach out to us at the firm or contact an attorney.
Okay, perfect. So none of it is illegal nor personalized advice.
Right. Yeah, this is just general.
And in some states, it could even be taken as an advertisement.
Yeah, in some instances, yes, which this is not either. But I'm happy to answer general questions and also provide some strategy guidance for any question you may have.
Sweet. So the first one is getting paid and protecting customers. And getting paid is, how can a cleaning company ensure that they get paid after every single cleaning job?
Yeah, I think there's two portions to this question. The first part, I'd say, is building good relationships with your clients and having some emotional intelligence. You and I discussed this earlier at lunch, where kind of the emotional personal relationship touch kind of goes out the window when people look at contracts and it becomes more of an adversarial situation. So I think the first part of it is kind of that portion. And then I think more to your point is you're talking about the contractual portion of the relationship that you have with any client.
Yes.
And so getting paid is obviously important to have good contract terms that lay out a variety of terms, right? So you have your payment terms. And what does that mean? Well, we're talking about invoicing, payment methods, deposits, timing of payment, and then potentially also late fees. And as your business evolves and grows, both as an individual business, but also with your clients, you'll get a better sense for where these risk pools are. And what I mean by that is if you have a good relationship with a client, perhaps it's a shorter term contract, maybe you're not so worried about getting paid because you know they paid you in the past, or you know they have deep pockets or whatever it is. But if it's a larger term contract and the risk starts to scale up, then you need to be thinking about, okay, how do I protect myself in the event things go sideways or things go wrong? And unfortunately, part of the job as a lawyer is for us is to help you identify risk pools and then allow you as the business owner to make decisions based upon how you want to tailor your risk profile.
So there are like a couple of, are there any examples that are must-haves in the language that you would prefer? For example, there have been instances when my cleaning company has done work for a larger contractor, and there was a terminology that I did not know of until I learned, saying pay when we get paid, right? And then when you are going as a small final end, like now that holds off because they don't get paid because now they have a punch list to do.
Right.
And that's dependent on other trades, mechanical, plumbing. So the whole thing can get dragged out months, if not years. So small company can't really afford that wait time. So therefore, I personally, like when I see pay when you get paid terms, or like guaranteeing something for a year. In general contracting world, that's normally a proper and applicable.
Right.
But how do you guarantee a toilet won't get dirty after it's been used next time, right?
Yeah, I think to that point, the provisions that I would look for in terms of protecting yourself and payment would stipulate, for instance, late fees.
Yep.
So how that's structured, you basically kind of create built-in protections whereby the cost of not obeying by the terms of the contract starts to go up.
I see.
And in another instance would be if you have a larger client over a longer term period, perhaps you create a deposit up front, and perhaps that money gets drawn out of that account, and then when the contract's over, to the extent there's anything left over, you can prorate reimburse as an example. I think the other portion of this is the enforcement of the terms that require the payment too. So, for instance, what happens if someone doesn't pay, even if the contract says that they should? So at this portion would kind of speak to how are disputes resolved. So within the contract, it might say we go to mediation, or it might say we go to court directly. And as you know, as a small business owner, getting tied up in litigation is time consuming, it's emotionally draining, it's frustrating, you have to pay your employees, these things get drawn out.
Right.
And so having both the good client relationship and also these terms can help mitigate some of those risks. You don't want to go too crazy because people get a little bit irritated when contracts are too dense.
Yes.
And so we do like to strike a balance between practicality and protection of our clients, but also going back to the relationship side, you don't want to drop a 500-page contract on someone's desk.
Right.
They're not going to read it. They're going to get frustrated.
Yes.
And as you know, in a relationship business, you want to keep things as streamlined as possible. So it's a bit of a balancing act.
Is there a rule of thumb, like, hey, don't go over 2 pages, or like, 5 pages pushing?
Yeah, that's a great question. I think it depends on the nature of the relationship, the duration and scope of the services, and also the sophistication of what needs to go on.
I see.
And you as a business owner can help educate us as the potential attorney to truly understand your business. And the theme throughout this entire conversation is that you really want to find an attorney who understands your business, both the day-to-day operations, but also understands your goal for that business in the longer term. And what I mean by that is, are you going to pass it off to your children?
I see.
Are you planning on selling it?
I see.
You had enough and you want to get out because your partners are doing things. And so it's a holistic approach when we talk about developing strategy, both for entity setup and formation, but also the day-to-day business interactions. We try to kind of strike a good balance between all.
And this is something your firm can also help out with, like during the communications, right?
Correct.
Like, if you feel that I'm like getting frustrated, then you're like, maybe, right, your options could be exiting, or, is that how you determine when you work with?
Yeah, I think like anything else, it's communication is big. I think that's the first thing, right? So as an attorney, potentially helping out set up an entity or understand a contract, my goal really as a lawyer is to understand not even the legal stuff, just all the background information. What are your goals? What's the situation? To really get a holistic approach, and that way, when you craft a service agreement or whatever other contract, you can really provide more precise value in a much more efficient way as opposed to a carte blanche form that may or may not be appropriate for whatever the situation is.
I see. One of the things you mentioned was the late fees.
Yeah.
That I like this mechanism because it's kind of like snowball, right? It keeps adding and adding more, and it kind of like puts, in my opinion, pressure on a customer because it keeps growing. But there is a legal limit as well, right? Like I can't go 10, 15, 20%. Like I guess it's state by state varies.
Yeah, I want to be careful in how I answer this question. Yes, there are limits, and those limits would depend on the situation. This would be like a specific conversation with an attorney depending upon what's going on. But correct, you can't say you owe me you know, all the money in the world if I don't get paid. And then to another point is just because you can pursue someone legally, you also, again, like we spoke about, you don't want to get into a situation where you're chasing down someone for a small amount of money and you're racking up a ton of legal fees and time and energy to do it. So you really want to kind of create smooth exit paths in certain situations, and this is where the provisions of a contract that talk about dispute resolution, deposits, or late fees can really come into play. And I think deposits are a good way of doing it, or you have pay as you go, or you can get creative in how you structure some of these arrangements, and that really kind of boils down to the relationship with the client and the nature of services that you're providing to that client.
Understood. Many ask in the communities, hey, I found a customer, I'm talking about a business owner, now they put a cleaner to do the work, and then a few months after, you know, they actually handshake with one another and abandon the company who actually created this. Just there's a risk because it's a human business. If business owner is unable to go to every single location every single time, then relationship is being created between this cleaner and the homeowner or property owner. Are there provisions that we should put in as a business owners to protect ourselves from that?
Yes, of course there are. So the first thing that I'd mention here would, I think, most obviously be a non-compete provision. However, there's some caveats to this. The FTC just came out with a proposed rule banning non-competes entirely. This is up in the air right now. So that aside, and frankly, this is kind of a subject for, this could be its own video.
Yes,
right?
I got you.
So I'm generally speaking here.
Right.
The non-competes have to be very narrowly tailored in certain situations. And this is a conversation that you should have with an attorney because the rules change state by state. But as a general concept, you can have a non-compete provision that may be in flux. That aside, you can have a non-solicit provision in your contract, right? So your current employees or contractors, depending on the situation, can't go out and, like you said, kind of on the side, solicit your clients for a new company or by themselves. And as part of that, you can also use, some confidentiality provisions. So kind of the proprietary information that your company has would include, say, a client list as an example. And so that client list is company property.
I see.
And it has to remain with the company. It can't be brought out. They can't have copies of it and things like that. So those are kind of the three, I guess we'll call categories of contract provisions that you could factor in to mitigate that risk.
So I had a case when this actually had happened to me, and a subcontractor that was working undercut. The customer called me back and said, this is what your person is doing.
Interesting.
It was one of the experiences, right? Rarely customers tell you. And I'm like, okay, how do I go back after this contractor? Because not only I was losing that actual portion of the income from losing that service, but that was a recurring service. So how do you anticipate the lifespan of it? After my research, one of the things that I had ended up implementing into my subcontractor agreements was a liquidated damages clause. What do you think about that?
Liquidation damages are another thing you can bake in as well. You're essentially baking in points of pain to not abide by provisions of a contract.
I see. Okay.
It's similar in the sense of having a late payment or a deposit for a normal service contract. So yes, you can bake in hurdles and pain points in these contracts as well. Again, you want to be a little bit careful about how you do it and given the situation. But yeah, that's also something you consider as well.
So now what we're talking is, first we talked about the late fees from the customers. That was one contract that goes to the customer facing, right? Then you also need...
Yes.
Okay, and that goes to your employees and or subcontractors. Is that usually one or that's two different?
They're separate. They're separate. The terms of how the relationship is governed between you and your employee or your independent contractor, that would be a separate piece.
I see.
And then you have a normal service contract between, i.e. you, the cleaning company, and XYZ client. Yeah, they'd be broken out into two separate portions.
I see. So if a business starts, at least it is recommended to have at least 3 contracts, right? One with customers, one with employees and one with subcontractors, should you decide to bring subcontractors.
Correct. Yeah, and you make a good point. The distinction between an independent contractor and an employee can be very important. And, and even within that, you would have a independent contractor agreement and then a separate employment agreement with your employees. And drawing that line and making sure that it's very clear how the relationship is established is important. And that's having a good employment attorney can really pay dividends in this sense.
I see. I probably know this.
So you've been on the actual real world implications. Yes. So I know you understand kind of the implications.
A lot of us, I feel like, and I was one of them. In the beginning, I was thinking like, hey, the money you write to a lawyer until you have a problem is kind of like a waste because you don't have to.
Yeah.
But it hurts because if you have to write it when you're faced with it, it might be a little too late.
Yeah. So this is a good point, and I think, having been on the business end, I can really appreciate the apprehension for people to get engaged with an attorney on the front end. It's expensive, it's time consuming. I completely understand. And also businesses have to make decisions. They have limited budgets, they have limited time, limited resources. They have to prioritize, how things drop in line on their day to day. On the other side, I would say that in a lot of ways, having these contracts in place is a form of cheap insurance. Maybe not the best analogy, but you're creating a protective net on paper that would also help you in the event that you get.
That's a good way of looking at it.
Different way of looking at it, and
sure.
Granted, I am on that side.
Right.
But that to me is the most logical explanation as to why you should at least be thinking about these things early on. Just have it on a list of, let's say I can't afford it now, or I'm too busy. You definitely want it on your to-do list at some point in time, or you should at least be having the conversation of how to set things up as your business grows.
I like that mindset of, hey, I would rather have an insurance and not use it as opposed to not have the insurance and now you have a claim.
It's almost like chapstick. When your lips are super chapped, it's like when you need that chapstick, you need it now. And, and if you can't find it, it's painful. It's probably kind of a silly analogy, but sometimes it works.
Gotcha. I teach SBDC classes as well, and on YouTube, how to start and scale cleaning companies. One of the bigger questions I see as well is, what type of entity do I start? LLC, corporation, sole proprietorship, incorporation, and now it's like C Corp and S Corp. Could you just tell
the alphabet soup. So this is, generally speaking, there's as you know, there are options to run a business. You, John, can just go do things on your own, drive around. I do not advise that under any circumstances. You can do it, but the problem with that is all the liability, everything falls on you as an individual, meaning that someone can come after your child's education fund, your car, your house, things like that. Then you have the traditional setup would be the LLC, the limited liability company. There are different rules for each state as to how they need to be set up and run, but generally speaking, they all follow similar guidelines. And frankly, for most of our clients, this is the structure that we would recommend. And the reason is because you get liability protection. And it's also a flexible structure as opposed to a corporation that's a little bit more rigid. The other thing to think about in terms of LLCs is you have how states view the LLC, as in the company, and then you have how the IRS views an LLC from a tax side. So it's kind of there's a seesaw in terms of how you want to think about strategy longer term. And actually taking a step back, the way that you structure your company is going to be driven by how you want the company to grow in the future. And what I mean by that, kind of talking about earlier, are you trying to sell the company? Are you trying to pass it off to your kids? What's kind of the end game? As an example, if you're trying to bring on investors, typically investors like to see more of a formal corporate structure as opposed to an LLC. There are upsides and downsides to this. Corporations are taxed at two different levels. They have more formality. They have board meetings and things like this. There's baked in cost, but there's some upside. For the LLC, which is most appropriate for most people, it's much more flexible in that sense. And then from the tax perspective, corporations are taxed at two levels. And LLCs, it depends on how the LLC is structured. So if it's John LLC, single member, the default taxation of that is what's called a disregarded entity or a pass-through entity. This is tax lawyer speak for the way the IRS views it is the income flows through the entity to you. It's going to hit your personal income statement. You still have the liability protection that the LLC offers. But from a tax perspective, it's as if the company doesn't exist. The income flows to you. As soon as you bring on a partner, even if it's just a fraction of a percent, the IRS is going to look at you as the default rule as a partnership. And so these are conversations that you should have with an accountant as to the implications of how your business grows and the tax portion of it. Now, the S Corp, as you mentioned, is another popular structure. And again, you should discuss with any accountants as to whether or not this is appropriate for you. But the S Corporation allows more of a tax. It's another tax play to reduce taxable income. And the rules for this is literally an entire class in master's tax courses in law school is just pass-through entities. But generally speaking, there are some rules about S corps that people should be aware of, i.e., 100 members or less. You can't do disproportionate distributions with some exceptions. And then there are some other rules. And so these things are important to be aware of, both from the accounting side, because it affects your taxes, but also from a longer term planning perspective, because if you violate some of these rules, it can kick you out of S corp status, and there's some tax implications for that.
I see.
So when you're structuring your business, you want to have an attorney who understands both the business, but also your goals as a business owner. Do you own other businesses? And kind of getting much more of a holistic picture to create an appropriate entity for you, and also the tax side as well.
So from when the cleaners are usually like solo people like me, just starting business, and we don't really go and raise funds normally because it's self-sufficient and you start. In those instances, you mostly see LLCs being created, and those are more favorable than sole proprietorships in general.
Yeah, I mean, I'm not giving legal advice here, but the LLC in most instances is often the appropriate way to go. Obviously, you should discuss that with an attorney, but typically that's what we see, particularly if it's a single founder person, business owner, that more often than not is going to be the appropriate route. And then, whether or not you decide to grow, raise funds, things are a little bit, they're not set in stone. There are some consequences for moving out of an LLC into a corporation back and forth. It is possible, but again, that's more of a strategy and planning play as your business grows and evolves, especially in terms of if you were bringing on different clients and things like that. So it's law is kind of fun in that sense, where things can be in flux and things are flexible. But you're right that the LLC is a common and often appropriate mechanism.
Seems more like a happier middle when you start.
It tends to be, yeah. It's also there's some yearly filing costs and some other administrative stuff, but the burden of setting it up and running it tends to be, it is lower than a corporation.
From a legal standpoint, is it correct to say, so let's say if we remove the partnership aside altogether, not to entertain, but get the sole proprietorship, LLC, and S corporation on top, would that be fair to say that the corporate veil, as you go higher, the protection-wise, gets thicker? This
is a tough question. The liability within, actually, let me back up. So you do have liability protection in all of these, like an LLC, be clear, an LLC, a corporation, or an S corp.
Okay.
Partnerships are a separate topic, and sole proprietorships are a separate topic. There's something what's called piercing the corporate veil, which is a legal theory whereby if you're doing extraordinary measures that are either illegal, not what the company was intended for, then yes, you can start exposing yourself to personal liability. Barring anything completely crazy, generally speaking, you have liability protection both as an LLC and also a corporation.
Understood. And then as an advice here, like go talk to an accountant as well, right? It's not just the
bingo.
You need them both.
Bingo. And to the extent that you need to bring in other experts, maybe it's a wealth planner. Or,
I see.
Or even, an accountant, obviously, I think is a smart choice for anybody. Having organized books and records, both from a legal side and an accounting side, to me, pays dividends down the road.
I see.
For me, it's having seen, and perhaps some of your experiences too can speak to this, paying a little bit of money up front to set proper contracts, get a good accountant. These things are worthwhile, particularly as things develop. Because if you have to do it on the tail end, cleaning things up can be much more expensive than just doing it right from the start and then not having to worry about it.
I can witness to that as well. On my personal, so if 2009 when I started, 2024 now, so we've been in business, 15 years? There are audits you undergo, not just legal implications, but there are also audit requests that come in and you get handpicked by your state to be audited. I can only imagine if I did not have my ducks in a row, what would it have cost me to just clean that up, to support the point that you mentioned. And over there, to have my ducks in a row, I was paying increments every month to my accountant. Here I would have paid a more gigantic fee at once, which is harder pill to swallow.
Yeah, we've seen this a couple times, even on the legal side too, where clients, again, because they were startup and they were managing priorities and costs and something to the crack, whatever it was, and as time went on, the cost that that stacked up was actually multiples of what it would have cost someone just to kind of set up on the front end. So, I'm trying to be fair in how I say this because I completely understand that all these small business owners are juggling priorities and costs and things like that, but it's at least something to consider.
Understood.
Yeah.
So when we talk about those costs, as a small business owner, you've been a small business owner, you know we need to balance what we want, what we can, what we should, what we must. And when we do that, we try to save cost. And nowadays, which something that hasn't been available in the past, they came up subscription services, legal subscription services. So in which instances you see the business owner taking advantage of those, and in which instances do you think it's better to have personalized consultation with a firm like yours?
Yeah, this is kind of a tricky answer. I think it's always better to have personalized.
Yes.
But that being said, I think for very generic things, perhaps like a non-disclosure agreement or some very simple contracts, then it might be appropriate to do that. I think the most appropriate instance would just simply be if you're uncomfortable with filing state forms to get your LLC set up, which is a fairly simple process once you kind of understand the mechanics of it. But let's just say you don't have time or are uncomfortable, then I think that's an appropriate instance to use, XYZ set up LLC through name the online legal service. I think once you get past kind of what I'll just call the setup stuff, you should start thinking a little bit more carefully about who you engage to draft contracts, particularly if it's for larger clients, higher dollar contracts. And again, every business owner understands their business better than attorneys do, hopefully, and therefore they can better gauge the risk level that they want to accept for whatever type of relationship they're getting involved in. I think there's a limited application for it, but I think, once you move past that, you really should start thinking about perhaps getting a little bit more personalized service. And you don't need it for every part of your business. Let's say you have all this stuff going on. You can just say, hey, I need this one service contract looked at. It's a bigger client. I'm worried about X, Y, Z. And you can kind of just pick and choose what legal services you want. You don't need to go all in all the time.
If I were to give some examples in my from my past history, how I was able to leverage it, right?
Yeah.
So like NDAs, as you said, or I have a company is giving me a contract and I want to review it.
Yes.
I could just like, hey, is there anything sticks out for you, right?
And that's a great point. We get that a lot. We have clients that come to us with pre-formed contracts that they want to start with to push the other side. And we also have clients, a lot of clients will get kind of on the other end as a client of, say, someone who provides your services, and they go, hey, I've read this, I generally understand it, can you please take a look? And perhaps maybe they don't have, late fees, or hooks, termination clauses are a big one. Hey, I'm not getting paid, can I terminate the contract? Well, this says you still have to perform. Oops, should have had someone look at that on the other end. So you can really tailor, one contract here, one contract there, or if you want a form built that you can then use on and grow with that form. There's a whole. It's almost like adult Legos. You can pick and choose what pieces you want to click together in that sense.
And when I had to come up with my service agreement to my customers that go standard now, I had to use a personalized service.
That's
lawyer and we had to talk. It took us days and not weeks, right?
Yeah, and this is the relationship portion, right? I can't draft you a good contract unless I understand your business and we have that personal relationship, hopefully, right? And then understanding not only your business, but how that business interacts with the clients. How do you get paid? When's your cash coming in? When are you paying your employees? These are all important considerations when drafting contracts, particularly as a small business.
So with one more thing that came up recently, which has taken the world by storm, it's AI. And now AI is generating templates. So if let's say I'm on Legal Shield site and I'm not satisfied with them, but I want some service agreement, is it more cost efficient for me as a business owner to draft something and go to like, hey, Offit Kurman, or like?
It depends on how you measure cost, right? So this can cut both ways. And I've seen it cut both ways, and there have also been attorneys that have gotten in trouble for using AI and been sanctioned by courts. AI is an incredible tool. My first kind of impression about AI is don't trust it, always verify it.
It hallucinates.
As an example, it will make up court cases. It's done this in the past.
Just making up
fabricated a court case. And the lawyer got sanctioned for it, and his response was, "Oops, AI did it."
Wow.
So it is a valuable tool. It's in the early stages of, or maybe not. I'm not a technologist, but I think there is use for it in very limited application, and you also basically can't trust it. But to your point, I think if you are trying to develop a form on the front end to bring to an attorney and you're trying to get it as close to final form to save cost, I go back and forth on this. We've had times where it's worked out pretty well, and we've also had times where we kind of took a look at it and said, hey, unfortunately, given the situation, we just kind of have to start over.
Okay.
And if you're okay with kind of accepting that cost, i.e. your time of doing it on the front end, to potentially have to rework it in a sense, then yeah. We don't use it at the firm, or at least I don't. At least not yet. There are a bunch of legal tools that are coming out, but right now I just don't trust it. But again, I do think as time develops, I am kind of curious to see how it goes on. But I also understand the attractiveness that clients. I mean, I have friends all the time. Like, hey, I'm doing X, Y, Z. Oh, I'll just chat GPT it.
Yes.
And my response is, okay, but have someone look at it.
Yes.
And also, kind of like other things, to some degree, you do get what you pay for.
Yes.
In some situations. So I will say, I cautiously say that it does add value, but you need to be really careful on kind of what it comes up with.
Understood. And help me to either confirm or decline. When you guys lawyers, if I come to you and I'm like, look, Clinton, I need a service agreement. That is something that I need. So you're going to ask me questions, but you're not drafting the entire thing from scratch, right? You usually have a boilerplate template and then you're tweaking it. So meaning what I'm saying is the time that you're putting in, you use the boiler template and twist it. Am I saving a lot when I'm going the GPT route and coming to you versus if I were to just to tell you like, hey, I need that.
Yeah.
But now I have a piece of it and you'll get it.
I understand the question. It's kind of a hard one to answer.
Okay.
I think on average, if I had to guess, right, I would say it's almost the same amount of time because we review the contract from start to finish regardless.
Right.
We're reading the whole thing.
Right.
It's not as if we have, let's say we pull a form from a similar situation and it's not like a fill in the blank kind of thing. We are literally starting over in the sense that we're in a new mental headspace, new client, new type of business, and so we will tailor situations to meet it. So it is kind of what you're talking about, but it's also kind of not, depending on the situation. And a good attorney will read everything start to finish, and to the extent they need to, they say pull in a specialist for an employment section or a real estate section.
I see.
So it's kind of a balancing act in that sense.
Understood. I just remember the case when we went and cleaned customers' property, and my company has been using eco-friendly, non-toxic, non-abrasive chemicals forever. Like since the inception, I'm like, why the whole industry is not using, right? I jumped on that and I liked it and I'm like, okay, I never charged extra. One of the customers called back and she's like, look, I had this fancy fixture that I had remodeled my bathroom and your product tarnished it. And she's like, you're paying for it. How do business owners, like in my case, I was able to go back, bring the sample, do the demo, show her that it does not tarnish to defend this. And I didn't have a cloth. After that, I put a cloth saying, unless you prove it that I did it, it's on you, basically. So how do you see like other companies deal with it or not deal with it, neglect? I'm also going with this to an insurance portion as well because we wipe somebody's TV and it's like, hey, you burned pixels, now replace my TV. So what do you...
So my wife runs her own service business as well, so I'm kind of familiar with some of the not antics, but like this kind of situation, right? So this kind of goes back to the contract portion that we were talking about, where all right, what portions of the contract can I think about? Insurance, having good insurance is important. That's kind of the aside. I think within the contract, there are things you can do to stipulate, limiting damages. You could also potentially have a waiver portion there, saying like, hey, here are the chemicals that we are using. If, for instance, like if you think your dog is going to react to a chemical or things like that, you're fully disclosing everything up front. People can, in theory, agree to that kind of situation. So those are some of the mechanisms you can use. And I'm sure, if we thought about this a little more, we'd probably come up with some sort of other creative solutions because this is kind of a niche industry. And again, having an attorney who understands what chemicals using, how are they being used, what are they being used on, these kind of things. And these are all kind of the silly things that nobody really thinks about because I don't spend time, you're a professional, you know much more than I do about the industry. And so really kind of pulling that inside out and applying that in a memorialized contract form is really valuable.
OSHA also has oversight over us.
I'm sure.
So they say, for example, we have to provide SDS sheets, safety data sheets to the customers, right? Saying what chemicals we use. We cannot use spray bottles that don't have a label on it because we can get a fine for it. Or if you have a bucket and you pour a chemical, you can't leave it overnight. It has to be with you because it's unlabeled. You don't know what it is. Work jobs, we can't wear like shorts or flip-flops because we...
PPE and things like this. You make a great point. I think whether you're in cleaning or any industry, you need to understand the rules and regulations that apply to that industry. And these are also probably state variant rules as well. So just because you're a cleaning company in Maryland, the rules may or may not be the same in Colorado or pick another state. So having good rules and regulations, having a good employee handbook, and then the other thing I would say is clear communication and training with your employees as well. You'd be surprised how many issues can be avoided simply with having clear communication and making sure everyone's on the same page. So that's kind of part of that. And then the insurance thing is kind of the worst case situation, right? But you should also have that in place as well.
To what degree the ignorance is a bliss can be applied to this?
I don't know if there's any bliss in ignorance when it comes to being a business owner. I think the more that you know, knowledge is power, and I think and that's also part of our job as an attorney is to really sit down with clients, understand their business, lay out options, and let the client decide. Like you are the captain of your own ship, the business, and we're I might be shoveling coal into the engine, helping you drive one way or the other, but it's your ship.
Let's say I was driving a vehicle parked in a customer's property and, hit their car or something, or their mailbox, and now there's a claim coming in, and it seems huge compared to what I thought it's reasonable. In those cases, if I have like an auto liability, right, I'm required to have them, especially if I'm driving a vehicle.
Right.
Do you see business owners normally calling their insurance agents, or they just calling the lawyers regardless? I mean, do lawyers get normally involved with this?
Typically, so I've not been involved in situations like this. I think normally this, to me, would sound like, it's kind of hard to answer this question, but generally speaking, this sounds like an issue that your insurance company would handle. Now, to the extent that it's some wild amount that somehow you would be personally responsible for, like let's say your insurance didn't cover a portion of it or didn't cover it at all based on some clause, then maybe at that point in time, you should engage a lawyer. I think always the first place to start, whether or not you're getting a subpoena or a legal issue or someone sending you a bill, is simply just remain calm, think things through, stay organized, and then to the extent that you feel you need to reach out to a lawyer, an accountant, the police, whoever, you can make more of an educated decision with a clear head. I think that's kind of taking a step back from just immediately jumping to
calling the lawyer. I've seen cases when insurance says, hey, if claim happens, we covered, but then the next year insurance goes up should the claim happen. Let's say normally it was going up 5%,
right,
and now it's like 35%. Like, what do we do then as business owners?
I think for that, the first thing is just to make sure what your insurance policy is and how it's changing. And unfortunately, in some instances, that might be a full-time job by itself.
I see.
It's been a while since I've owned a business, but as you know, keeping track of all these moving pieces can be difficult. And unfortunately, sometimes the implications of missing small details, particularly in the legal space, can be very problematic. So I would just say keep abreast of both state rules and regulations, and then also what your insurance is or is not covering. And if that means simply picking up the phone and calling your insurance company, and hopefully they have a person you can talk to, I would strongly recommend that people do that.
That's why I like dealing with brokers. This building that we're in now, right? When we acquired, there was strong wind, the roof was old, and it literally folded. I wasn't even here, and it was storming, and it leaked down all like two floors down, and the neighbors over there, dentists, they didn't know who to call, because I was just a new neighbor. And then I go there, and in my head I had this case, if I put a claim, my insurance is gonna go up, right? And I call my broker and I'm like, dude, I'm looking at 10,000 minimum, if not more. It was more, I come to find out, and he's like, call and put a claim, right? And then, but there were cases when I had called him and he's like, dude, don't bother, just pay for it, like a couple $100 and you're gonna be done.
I think this, kind of like any other instance, is if you have someone who's an expert in that area, whatever it is, insurance, cleaning, whatever, you pick up the phone. I think people have also kind of forgotten a little bit that they can just pick up the phone, right? We've all gotten so used to texting, emailing, these instant exchanges, and I see it all the time where people just pick up the phone. You'd be surprised how far you can get with just being pleasant over the phone. It's like really kind of luring in flies with honey, not vinegar kind of situation. I think really it will pay dividends in any situation.
I guess that keeping in mind that the person on the other end has a power, and it's usually not the AI or algorithm, but someone signs off on it, right? If they're prepositioned towards you and they kind of like you, now they're more inclined to help you out. So treat everyone as you like to be treated, right?
I could not agree more. Both in dealing with your clients, or dealing with insurance companies, or dealing with anybody in any context where you want to have a good long-term relationship. I think you'd be surprised how far you can get by just frankly being polite and courteous and maybe a little bit patient too as well.
We talked about employees as subcontractors really briefly. So the employment is completely different animal when it comes to, and then states are regulating it more harsher, like harder, or there are more regulations because there are like more potential openings for lawsuits happen compared to employees versus subcontractors. Are there like rule of the thumb things that business owners need to do? Because normally when we go in a business, I'm the one who's cleaning, right? And at some point, I'm going to start enrolling my friends, family, but then I'm going to grow out of that circle. And now I'm bringing in strangers. So
right. Yeah, I think so. Protecting yourself from the employee perspective, obviously you want to abide by normal employment laws, right? So anti-discrimination, immigration laws, OSHA, EPA kind of things. Part of that also would be having perhaps an employee handbook. Training and communication is big. So these are all kind of like what I'll just call like the softer skills. And then to the extent that you decide you want to bring on someone as an employee or a 1099 contractor, you would have an employment agreement or a contractor agreement. And employment law is its own vast area of law, like tax. Having a good employment lawyer is excellent. We have great employment lawyers at the firm. We've been doing it for 30 years. And bringing them in, I learn something every time I talk to them. And having that person in your pocket, on your Rolodex, if it's for specific questions or setting up forms that you can use down the road, I highly recommend that for anybody.
And laws change state by state, right? Like minimum wage is different here.
I think to any area of law, or almost any area of law, these rules can vary state by state or federal or timing. You really should keep abreast of any law, whether it's law specific to your industry, law specific to employment, perhaps tax law, and it can definitely be overwhelming. There's a lot going on, but at least have a general sense of kind of how things move. Law is fluid. It changes. I mean, tax laws change significantly, employment laws, political timing things. And so having at least a general sense of where things are, and then also having a good business attorney, part of our job at the firm is to kind of keep in line with these things and let our clients know. A perfect example is that FTC ruling about the non-compete thing. So we send out a notice to our clients, hey, just so you're aware, this is going on, we're going to keep track of things. And so it's another value added,
That's what you mean when you say law is fluid, right? Because
yes, it changes. It's in flux.
Gotcha.
Often.
If business owner charging employment and all the other stuff, you don't really have time to.
You're running your business. You've got a family, you've got kids, or 3 businesses, or whatever it is. And so part of the value add of an attorney, and kind of going back to, I've been watching a lot of the casino and the mafia movies, like having that consigliere, or this is like a really abused phrase, that trusted business advisor. Having a lawyer who understands your business and has a good resource pool of accountants or other specialized attorneys, but also understands kind of the evolution of how things are moving to help you as a business owner manage risk is effectively what it is. Yeah.
Are there any stories that come to your mind based on the scenarios that we discussed right now, which could have ended either winning the case or losing the case or put a big blow? And I have one more question at least to ask you before that. So
I'm here for you. So ask as many questions as you like. But I think in terms of what you're talking about, so if I get involved in litigation, it's I'm on the transactional side.
Okay.
So that's
what that means.
Transactional means like day-to-day business contracts. Okay. Not involved in court. I see. Litigation. So that's a whole other area of law. As if it's kind of like you're a doctor. What kind of doctor are you? Cardiologist, eye person.
I see.
Litigation is an entirely separate bracket of the firm, which we also handle. That being said, things go to litigation when there's a dispute. Someone hasn't paid, and so that falls back to, in part, having good contracts set up. So in terms of payment, like we talked about earlier, payment terms, late fees, termination portions, like when can I back out of a contract if I just want to say, hey, it's time to move on kind of situation. So that is more of kind of the front end mitigation sort of insurance, like that cheap insurance policy we kind of spoke about earlier. That is really where the value add is prior to getting to litigation. And kind of as part of that litigation portion you're talking about, contracts within them will have provisions that discuss how disputes are handled. Does it go to mediation? Do we have our cousin decide? Or, that's kind of a weird example.
Yes.
Or does it go to court? And so that's partly how you can manage and dictate what happens if things don't go well, which no one wants to think about or kind of imagine. But unfortunately, life happens, right? So you just want to have baked in contingencies where everyone knows, hey, in the event that XYZ happens. Here are the mechanical steps for how we're either going to fix this or just say, hey, no, thank you, and move on. It really just kind of depends on the situation.
I've got a person coming in to be interviewed soon, and there was a case where the lawsuit was brought up 1099 versus the W-2 employee case, and then the jury found the owner, the business owner, liable for $6,000 or so case, and slapped all attorney fees that were $67,000 on services and over $8,000 in just fees or applications and such, which is now sinking the business. That seems like extreme, but those things happen.
These things do happen, and this is kind of also part of what you need to think about in terms of if things go wrong, is it worth me pursuing it after that point? Right? So as an example, let's just say someone owes you $2,000, and let's just say for whatever weird reason, it's going to cost you $5,000 in attorney fees to track down $2,000. The math, even I can do that math, right? And so there are portions in contracts, this is called a prevailing party clause, whereby if it does go to court, the person who wins basically takes the house, meaning that you get your $2,000 back, and the other person now has to pay for your legal fees as well.
I see.
That edge cuts both ways, right? So if you have that provision in your clause and you lose, you're now on the hook for their things. And European law is kind of similar in the sense, but that's kind of how it happens. It's different but similar. But yeah, this is what's called the prevailing attorney clause. Right. You'll see that in contracts. And the more you read contracts, contracts are almost very similar to learning another foreign language. It's a lot of pattern recognition, right? So you'll know that most contracts should have indemnification or things like that. Right. And so as you read through, you'll think, oh, hey, wait a second. My last service contract I saw had XYZ provision. Why doesn't this one have it? I see. And if it does have it, how is it drafted? Because you can draft things both ways. We can have a provision that says both you and I can assign the contract to someone else. We just need consent. Or it might say you need consent from me if you want to assign it, but I can assign it at any point in time without your permission. I see. And so just because it's there doesn't mean it's favorable to you. You want to be very careful in how you parse some of these things out.
And as you said, as I had gone through these, like some of those things, I just already if a customer sends me their subcontractor agreement, if I'm their subcontractor, let's say it's a big home improvement company, right? I scroll down to the warranty immediately. I go to the payment terms
because you know where to look. Yeah, exactly. You've had experience, and your brain knows. Oh, I've seen a couple of these before. I know where to look, or I at least know which portions are more material than others. Right. Because sometimes, again, you have time constraint, you have efficiency constraint. Right. So liability, indemnification, termination clauses. You kind of want to go to the real pain points. In which case,
confidentiality, right? For example,
another big one.
I had a case, believe it or not, I had no clue about that. I went and cleaned somebody's house. We took photos and we posted the team cleaning photos. And we posted the outside of the property as well photo. Yeah. And customer reached out and you can't do this. I'm like, what did I do wrong, right?
You also have, what I would call what's legal, and also kind of, again, how do you manage because some clients don't care. They'll say, hey, I really like you, I want to support your business, have at it. Yes. Right? And other people value their privacy, and they don't want pictures of their home on the internet for a variety of reasons, which are understandable, frankly. And so, even in a situation like that, the easiest thing might just be to ask. You just say, hey, I'm trying to, develop some marketing material. I won't list your address. Maybe I'll have certain photos, or here are the photos I took. You can take a look. Do I have your permission? And that just, again, you can even kind of, this goes back to the personal relationship as opposed to, in theory, you could have them sign a waiver. We can do that kind of thing. But just skipping over the legal stuff, just going back to that personal relationship.
To see if they're okay or not.
A lot of people just say, no problem. My wife has this all the time where she wants to film, she clips dogs' nails, and so she'll ask, and people say, no problem.
There was also a case when we cleaned warehouse floors, and it was so messy. And we just put before and after. We thought it's so great. And the place was selling food.
Oh, yeah. So that, to them, they don't want to be advertising that.
Exactly.
Yeah, you want to be careful. I think, asking for permission, I think goes a long way. I think it shows courtesy. I think it shows some maturity and emotional intelligence. And I think it also just helps even aside from the marketing material, it just helps establish like, oh, there's a person on the other end of this contract. So I think it goes along.
I couldn't agree more. Like each time now we ask, is it okay to take photos?
Yeah, that's
right.
Smart.
And then some people I'm seeing on contract, they put a clause, by signing this, you agree that I get your before and after photos and post
You
them.
can do that.
But then normally they also ask, right? Like, hey, it's in the contract just to protect you. But
yeah,
then
I think, obviously as a belt and suspenders approach, putting things in writing is always better than not in that sense.
Yeah.
Again, you don't want to drop a 500-page contract on someone's lap, but it's in some situations I think it's appropriate to paper things as opposed to having just an oral agreement. And it could even just be an email in some instances too. Right?
Your text message, right?
Yeah, just to have it in writing, hey, excuse me, sir, trying to do some marketing, is it okay? I'll provide photos for your approval beforehand. Yes, and then kind of move on. I think it just depends on the client. Obviously, if you're dealing with residential versus commercial clients, things start to change. As the risk profile goes up, and then you want to think a lot more seriously about having a waiver or, or something papered.
I see. We spoke about a lot of how things can go wrong. I mean, I guess that's what lawyers usually talk to, right?
Like, I gotta go to, why do you go to a dentist? Because you have a cavity. Why do you go to a lawyer?
Right. How about something that's more on an optimistic note? We, the business owners, that as a ex-business owner and possibly future business owner at some point, we try to build our legacies. And one of the bigger questions on the community is it best to be the part of the franchise or individually? So many people lean towards individually. I'm not saying one better than the other. I'm just saying that that's what normally people choose. And then should we succeed, we're building our brand, it's the ego and etc. Let's say I build my brand and it's great now. How do I protect?
Yeah, I think the first two things that people think about traditionally are copyrights and trademarks. So branding, intellectual property is a very niche area of law. So this is an instance where people also will use legal subscription services for this. I'm careful in recommending those. I can't really speak one way or the other. All I will say is that IP is a very sensitive area of law, and your brand is important. Marketing is important, and I think those are things that are worth protecting. I'll leave it at that as far as whether or not you should contact a lawyer or use a subscription service. But however, so you have copyrights, trademarks. We talked about the trademark portion. The copyright portion would be, do you have any specific processes that you use? Copyright can be a little tricky in the sense that I feel like you should absolutely engage
an attorney
for the copywriting portion is a step beyond in sophistication in my eyes than a trademark. So those are the two major things that people think about. I think you can also do, if you're worried about your employees or contractors kind of starting to poach in this area, you can also have non-disclosure or confidentiality agreements that would protect proprietary information of the firm. How you do your cleaning processes, how your software is structured, maybe how your routes run, all that kind of stuff can be rolled into this. That's more of like an internally facing protection as opposed to an outward being the copyright and trademark.
Correct. And let's say I created it now and somebody I saw it using the language or the verbiage or the technology, then what normally happens? Like, Susan, this is let it go.
So this is where you would want to get a lawyer engaged. And again, I don't do litigation and I don't do copyright and trademark, but traditionally you'd engage a lawyer, there'd be perhaps a cease and desist letter, and then kind of going beyond that, just from like a common sense perspective, you would probably want to keep an eye on the activity of whoever you thought was stealing your stuff. I've seen it happen in a couple instances. Usually it's like, bakeries with
I see they get the formula, right.
Stealing a design, things like that. And people do silly things sometimes too. Well, they'll blatantly post it on the internet. A friend of mine's a watchmaker, and he films these very specific watch kind of repair videos. And he found out that some guy I think it was Germany actually, was stealing his videos to use as advertising material. I don't even know how he found out. But these are things that you can kind of keep an eye on. It's not as hard as you think in some instances, because people it's the internet. People just slap stuff up there. And so anyway, monitoring behavior like this kind of just generally I think is good. And traditionally, if you have clients who like working with you or your friends and family, sooner or later, someone's probably going to see something and say, oh, hey, John, some guy was using your video or stole your logo. My wife had it. Some woman on Facebook literally took her logo, made it a different color, like changed one or two
and
things.
That's it.
Yeah, and I forget how we found out. I think it was actually one of her clients pointed out. Said, hey, just so you know. And
you guys took an action or just ignored in this
we
case?
sent her A polite email is effectively, and she took it down. I think, again, there are instances where it's simply appropriate to just pick up the phone or an email and say, listen, please stop. And if they stop, then excellent. And in this instance, it worked out. And I think she actually apologized. She was younger, and it wasn't like a completely malicious thing.
Yeah.
She kind of
like ignorant.
A little bit. Yeah, I think it was a little bit that just took a little bit too far. And she said, "Oh, I'm sorry, you're right." And so that was it. That was the end of it. But if it does go beyond that, or particularly if it's no longer like a startup person using it as opposed to an actual
business or something,
properly functioning entity, then there's probably a little bit more behavior that's not just accidental.
I see.
In that instance, yeah.
I see. So unlike some countries, in U.S. copyright and trademark are more enforced, right? Like,
I can't speak to whether or not they're more enforced or not, but I can say that they are important.
Okay.
For sure. I mean, Disney, Coca-Cola,
right?
Name any large...
Nike, right? Like all of them, right?
All these things are very important.
Protected.
Yeah, they're important. And frankly, you work hard
to
build this business.
To build the brand.
So you should protect it. And you shouldn't feel embarrassed or whatever about having to defend it. I think it's natural.
And you mentioned that you guys located in Maryland. Do you only service the Maryland clientele?
So Offit, we're a 300-ish attorney firm.
Okay.
We are kind of focused on Mid-Atlantic, but we have offices out in California. We've got New York.
Okay.
We do, outside of personal injury and a couple other perhaps very strange areas of law, we really do everything. And also we have attorneys that came from some of the top firms in the country. They could be at pretty much any big law firms in New York, white collar firms, and they come here because frankly we have awesome clients, and they're fun to work with, and they do sophisticated work, and we just really enjoy. I much enjoyed it. Like, this is perfect. I love this. We're talking with our clients, doing their business, and that's part of the value that we can add, I feel like.
So all of the points that we just mentioned here, employee contract, the subcontractor contract, customer contract, trademark collections, liability protections, corporate veils, establishing LLCs, those are the things in your wheelhouse in your company. Like, let's say if somebody I don't want to do the subscription service, right? I want the lawyer to do that. Then how do they get a hold of you? And do you guys specialize in those services?
Yeah, so law firms, some law firms will specialize in one area of law. As an example, you'll have like a boutique tax law firm, a boutique litigation firm. So as a fully functioning, full service law firm, we do everything. So you can, obviously our website is open, my email's up there as well. But in terms of the services that we offer, we tailor services to large clients and big clients as well. So we do everything in between, all, real estate, private equity transactions, litigation, wealth and estate transfers, tax stuff, corporate work. I mean, we can kind of go on, we can go down the list here, but we do pretty much every area of law. And we have specialists in those fields that have been doing it for a long time. And because they've been doing it for a long time, they're very efficient and very sharp about identifying issues. We'll have a conversation like this in your business and then start identifying issues that we present to you. And again, you are the captain of the ship. You just tell us what, do you want a 1,000-page contract? Do you want a 2-page contract? I see. Want it all, like things to think about. So once you you now have a Rolodex of resources, and that is very valuable, I think. And both for me as an attorney from a learning perspective and, helping my clients, but also from a client perspective where you can get part of our job is to education, right? So you can now draw on these pools of wisdom and experience that I think are really important.
We will leave all the links in the notes for how to get a hold of you or how to get off your organization should people want to work with you further.
Yeah.
Thank you so much for coming here. Thank you so much for the wisdom, the information that you've provided, and I'll look forward to seeing you at some point soon.
Yeah, thank you so much for having me. I really appreciate it. It's been a pleasure.